a month left in this Supreme Court term. Oral arguments have long concluded, but now we are on opinion watch. We didn't come to you last week as my two colleagues here were too busy vacationing elsewhere. I don't know exactly where they were, but they were too good for me. And I don't like to talk by myself. I need an audience, and you guys are it. So welcome back. We had 2 opinions last week, but 6 more this week for a total of 8 opinions to get to. So that's where we're going to start. We're also going to talk a little bit about a complaint that was filed using the court's original jurisdiction, Florida versus California. And there's, of course, more redistricting talk once again before the court. And we'll end with a little trivia for my colleagues. Joined by those colleagues, Damian Schiff, senior attorney in PLF Environmental and Natural, ENR, Environmental Natural Resources Program, and Oliver Dunford, a senior attorney in our Separation of Powers Program. Let's get right into it, fellas, with the opinions. And why don't we start with some of the opinions from this week? And there are 2 criminal cases that came out very similar, Rutherford and Fernandez. Oliver, why don't we start with those?
Sure. Both cases involve a statute that allows people in prison to get released early. It's commonly known as the Compassionate Release Statute. Cases were released on the same day because obviously they address similar issues and they were Rutherford versus the United States and Fernandez versus the United States. In Fernandez, the defendant argued basically that he was innocent, that one of the witnesses against him testified, reached a plea deal with the government, testified against him, and there's some thought that maybe the witness was protecting his brother, who may have been the actual shooter. Who knows? There was, but what the court said though is that, and let me back up one point here. In order to get released under compassionate relief, you have to show extraordinary or compelling circumstances. But what the majority said, and both decisions were written by Amy Coney Barrett, and what the opinions, or what the Supreme Court said, is that you cannot use the compassionate release statute to get early release based on actual innocence. And the reason for that, she said, is because there's another statute, the habeas corpus statute, that allows you to raise those kinds of post-conviction challenges to your sentence, to your conviction, to your sentence, and therefore you can't use this kind of statute, or that this doesn't. The post-conviction relief challenge that Mr. Fernandez brought was not an extraordinary or compelling circumstance because of the existence of that statute. Then in Rutherford, there were 2 cases heard together, and in both cases,
I hear the police are back.
Unbelievable! They're coming. You can hear everything except my voice through this microphone. It's ridiculous. In Rutherford, there were 2 defendants who were both sentenced to very long sentences because of the way the sentences were issued at that time. A later statute would have had the effect of reducing the sentences in both cases, but the statute did not did not say that they would apply retroactively. And so under normal statutory interpretation, statutes apply going forward only, and therefore, again, the court said that there was no compassionate relief here. There weren't extraordinary or compelling circumstances. In fact, the court said it's very ordinary for statutes to apply prospectively only and not retrospectively.
I guess my first question to you, if I can just cut you off there, is I don't remember which was which, but one of the opinions was 7-2 with the Sotomayor concurrence, and the other one was 6-3 where she joined the dissent. The dissent in both ones, including Justice Jackson, Justice Kagan.
Yes.
What was which one did she join the majority, and why did she flip in the other one?
Fernandez, which is the one that involved the actual innocence argument. Sotomayor and Kagan filed, or Sotomayor wrote a concurring opinion, which Kagan joined. So that was an 8-1 on the judgment.
Oh.
And what Sotomayor and Kagan said is that you cannot use the compassionate release statute to raise issues that had been raised before, which is what happened in Fernandez's case. He had raised these arguments multiple times. He was trying for another bite at the apple. What Jackson said in dissent there is that there's no reason this can't be a compelling reason to shorten the sentence. And she, of course, raised her big issue, which is legislative history.
Okay.
And then in the other,
Of course you did.
yeah, and then in Rutherford, which was the sentence disparity, that case actually involves an interesting issue of judicial deference. And one of the things that compassionate relief statute says is that there has to be extraordinary and compelling reasons, and that the reduction is consistent with the applicable policy statements issued by the Sentencing Commission. And what the majority said is that, yes, that's true, but the Sentencing Commission's policy cannot be contrary to the statute. And Sotomayor wrote a dissenting opinion in this one. So this one was 6-3, and her dissenting opinion was joined by Kagan and Jackson. And she said the Sentencing Commission included, one of the policy statements was disparate sentences should be taken into account. And so the interesting thing is, and I look back at Loper-Bright, they both cite to Loper-Bright. Loper-Bright overruled Chevron, of course, which said that courts should give deference to ambiguous statutes. And one of the premises of Chevron, though, was is that there was an implicit delegation to agencies to determine these ambiguities. And the majority kind of sidestepped that issue on this point. And so it raises an interesting question down the line for how is Loper-Bright going to be interpreted, because in this case there was an express delegation, not just an implied delegation, and yet the court still said we're not going to give deference to the agency here.
I see. So the express delegation to the Sentencing Commission says the Sentencing Commission gets the right to decide ambiguities?
No, but the statute says that the compassionate justification, or compassionate, whatever the hell it's called, that there has to be extraordinary and compelling reasons, and has to be consistent with the Sentencing Commission's policy statements.
Right.
And so the dissent said, well, the Sentencing Commission said one of the reasons can be disparate sentencing for similar crimes, and the majority said, well, that exceeds the statute, statutory language, because the statute says, the statute did not make an express provision for retroactive effect.
Do you see this? I mean, that is an interesting thing to highlight from the two sides, how they both cite Loper-Bright for their reading for their judgment. Do you think that is sort of a unique feature of the Sentencing Commission, or do you think that this is the first foray into interpreting Loper-Bright and highlighting where there's going to be future conflicts?
It's a great question. I don't know, and I don't know if the majority didn't mention it until the very end, and I think in response probably to the dissent statement. So I don't know if who knows how these things were written. Actually, I find the question on the first case, which involved again this was the actual innocence standard. I kind of find the concurring and dissenting opinion somewhat persuasive in that it does seem like the majority there just adopted here's a kind of a non-textual exception, that if there's a way you can do this through the habeas, then you should have done it that way, even though the compassionate release statute doesn't say anything about that.
Damien, you have any thoughts on Rutherford or Fernandez?
Well, I do think they are a nice balance to the Mississippi habeas case that I expect we'll be discussing presently, because I think Oliver is right that the main thrust of these two decisions is to establish this anti-circumvention principle when it comes to alternatives to habeas, that the court is just very reluctant to indulge ways of obtaining relief that outside of the habeas framework that otherwise could be. And the reason for that is because Congress has, through many laws, made it very hard to obtain habeas relief. And the idea is, well, are we not then effectively frustrating those policy judgments about how, you only get a year to file the habeas relief, that it has to be, raised in a certain way, that the state court, federal court review of the state court judgment is very deferential, all that stuff. Don't we effectively nullify that if we entertain a de facto habeas request in the context of compassionate release? So I think that that helps to explain some of the anti or non-textualist flavor of these cases. Although that being said, the statute is compassionate release, and I think as a matter of ordinary meaning, when one thinks of compassionate release, it's that yes, you're guilty, but there are these other concerns that make your continued imprisonment inappropriate. You have to take care of minor children, or you're terminally ill, or what have you. It's not like, oh, actually you weren't guilty. And so it would not be compassionate enough for us to continue to imprison you. I mean, that's kind of a mismatch. So not to say that it's totally anti-textualist, but I think Oliver is right that there's a little bit of purposivism kind of lurking around here. But I think it is balanced, because then the court kind of went out of its way in this Mississippi case to grant habeas relief in a per curiam opinion.
Wait, are we talking about?
Not per curiam, sorry.
Yeah, we're talking about Pittsburgh versus Kane, right? The Batson case, right?
Right. Yeah, that was not per curiam, but it is a habeas case where relief was granted.
Yeah, so let's talk about that case. That's a 5-4 opinion. Look at that. That's like a professional transition that you pulled off there, Damien, isn't it? That's good. This is Pittsburgh versus Kane. It's a 5-4 opinion. I think the first 5-4 opinion, maybe not the first 5-4 opinion of the term, but a 5-4 opinion. This conservative court ruling that the person on death row gets habeas relief. An opinion written by Justice Kavanaugh, joined by the Chief, and Justices Jackson, Kagan, and Sotomayor. And Justice Gorsuch writes a dissent in which Justices Barrett, Thomas, and
Alito
joined. Yeah, there you go. This case concerns a Batson challenge, which is a challenge to jury selection that prosecutors usually have peremptory challenges to certain juries. If they strike a juror of a certain race, the defendant can raise a Batson objection saying that this was racially motivated. Then the prosecutor usually has to give a non-racial reason for the challenge, at which the defendant can then rebut. What happened here, I guess there's a little bit of dispute on exactly what went down factually, but the prosecutors struck 4 out of the 5 jurors in a capital murder case that were black from the jury pool, leaving a 11-1 white jury. The defense attorney objected that these were racially motivated challenges, in which the prosecutors gave a couple of reasons why they weren't. One was one juror was late to a hearing. The other juror had, was under 20 and had a kid out of wedlock like the defendant, and the other ones had either family friends, I think, that had committed other violent crimes. So those were his race-neutral reasons. The judge accepted it, and the case went forward, and the defendant was ultimately convicted. There's some debate about whether I guess it's largely the whole debate is whether the defendant had preserved these objections properly, or whether he properly raised his Batson objection. From one perspective, he raised it when he went to the court and said, I want to just preserve my Batson objection. The court said, yes, it's in the record, you've preserved it. In one view, that was enough for him to have properly raised the Batson issue. The other view is, well, he never gave a reason why why the prosecutor's reasons were pretextual, which is an element that you have to give to properly raise your Batson objection, because he failed to do so. It was never properly raised, he waived it, and therefore we can't entertain it now. So Damien, that's sort of the factual backdrop. He had appealed this through the state courts. That didn't get anywhere, so then he pursued the federal habeas relief. And what did the court say?
Sorry, dramatic pause there. Well, basically, the court said that the Mississippi Supreme Court got it quite wrong. This goes back to what we were just talking about in terms of why habeas relief is challenging. It's not a de novo review, as typically legal questions are. It requires, I think, that the state court have ignored clearly applicable precedent and has committed a clear error, something to that effect. Anyway, Justice Kavanaugh's opinion says that yes, it did, because in this Batson test, there are these 3 steps that you just mentioned, Mr. Thompson, and that given the timing of when defense counsel raised Batson, Justice Kavanaugh concluded that the only possible objection he could have had was a step 3. And that's because at step 1, defense makes the prima facie case. Hey, race is being used here. Step 2, the prosecutor says, no, it's not. Here are these reasons. And it was only after the prosecutor had spoken, saying, here are these reasons, that then the defense counsel said, we want to preserve our Batson objection. Well, the only thing to preserve at that point is the argument that, I think as Justice Kavanaugh calls it, it's the comparator argument, that there were people that there were white jurors who were similarly situated in all the respects of the black jurors who were dismissed. And so therefore, it looks like that the non-racial reasons given by the prosecutor were pretextual. And to me, that makes a lot of sense, because Justice Gorsuch's dissent talks a lot about, well, no, I mean, they were just preserving their statistical argument that in this county, at the time, 40% of the population is black, and the jury poll didn't reflect that. But I don't see how that argument would have any strength after the prosecutor then goes to step 2 and says, oh, well, you've made your prima facie showing of statistical imbalance, but now I'm giving you a non-racial reason for why that we have that statistical imbalance. We just simply got this group of people, and I directed these jurors to leave because of these non-racial reasons. So I think what Justice Kavanaugh was saying is that it makes no sense to interpret the record to say that at this point in the proceedings, defense counsel just wanted to preserve an obviously otherwise losing argument. Mm-hmm. That if you've got to step 2, why preserve your step 1 argument? You know, the only
I get that point.
I'm misreading, but I mean that I think is why the majority here thinks that the Mississippi Supreme Court clearly got it wrong.
I think that's fair. I mean, I would push back a little bit and say you can't preserve an argument that you never make. So yeah, you can say the words, I preserve it, but if you never made it, then what are you preserving? Which I think is Justice Gorsuch's point. Like, okay, you said you didn't ever make an argument for why those were pretextual objections. You just said, I preserve it after the court ruled that it was going to allow the jury to go forward. And frankly, I think that's where the error lies. It's the defendant objected, the prosecutor gave non-racial reasons, and the court said, okay, I agree, let's go forward, without sort of inviting a response from the defendant to say, are these pretextual, which presumably at that point he would have given a reason if he had them. So,
well, not only that, but I mean, the trial judge here actually said your objections are preserved, or something to that effect.
Yeah.
So,
yeah.
But I think it's jurisprudentially. Sorry to cut you off, Al, but to me, it's an interesting timing, because we were just talking about these other 2 cases that have said, oh, sorry, if you want relief, you got to go through habeas, even though, oh boy, habeas is very difficult. Well, now here's the court, with Justice Barrett, of course, in the dissent, which is also interesting, but the court here saying, okay, right, we're here to show that habeas is not impossible. That here's an example of where the relief is from.
That's a good point, and I will say that's not gone unnoticed by Justice Gorsuch, in that he says habeas ought to be hard, and here you're sort of letting them off a little bit easier than we have in those other cases. So,
Just very quickly, I was on a panel, and I think I mentioned this last time when we talked about this case before, and one of the other panelists was, I believe he was a former U.S. attorney in Mississippi, and he said that the Supreme Court the U.S. Supreme Court has dinged this judge and this prosecutor before for similar problems. But he had experience in criminal law, and he said one of the questions that is not yet resolved is a point one of you made. I wasn't listening very carefully to you two, but one of you made the point that there's a question whether the judge is obligated to allow the defense counsel to make the points, or whether he's obligated to say, hey, do you have anything more to say about this, or is it all the defense counsel's job to raise those points? So.
Well, let's stick with you, Oliver. Flower Foods versus Brock was a federal Arbitration Act case, and that's about as much as I know about it.
Federal Arbitration Act has an exemption, or it applies to most workers, but there's an exemption for workers who are engaged in interstate commerce. And in this case, Flower Foods is a big interstate company. It contracts with this individual named Brock, who picks up deliveries in Colorado, drives them to another place in Colorado, and that's the extent of his effort. So he never leaves the state. He sued Flower Foods, and Flower Foods invoked the arbitration clause in the contract and said, we want to arbitrate this. And Brock sued in federal court. And so the question is whether Brock, by continuing or completing an interstate delivery, even though he never leaves the state, whether he's engaged in interstate commerce to invoke the exemption. And the court said, in fact, that Brock was engaged in interstate commerce, and therefore the Federal Arbitration Act does not apply. In other words, Brock fits within the exemption. A very short opinion, unanimous. Gorsuch wrote the opinion. And interestingly, though, the court says the statutory text does not support the Flower Foods argument, but he says when the FAA was enacted, engagement to take part in, et cetera, and interstate commerce meant, et cetera. So they interpreted the terms based on when the FAA was adopted. And then later in the opinion, they go on to say that the Constitution's Commerce Clause is not coterminous with the language in the FAA. And so I wonder if there is a chance that the court will judicially narrow its interpretation of the Commerce Clause. And it doesn't have to be inconsistent, because it says, well, that's how those terms were interpreted back when the FAA was adopted, which of course is not at the same time when the Constitution was adopted. But that's it.
That is interesting, and I do remember that issue coming up in the oral argument. It seems like they were pretty intentional about writing that in there. So
Definitely had to be. Yeah.
This reminds me, was there an earlier decision this term dealing with interstate transport from like California to Nevada, or is this ringing any bells from this?
Yeah, I think, yes, it was
A tort claim or something, negligent driver.
Oh, no, I'm thinking of a different Federal Arbitration Act case from this term. It involved employment discrimination. And there was a stay placed on the federal employment discrimination case while the arbitration happened, and the question is whether the district court retained jurisdiction to adjudicate the post-arbitration.
I remember that one, yeah.
But the case Joshua was talking about was a question about federal preemption. There was a driving, there's regulations about interstate driving, but the act excluded health and safety questions and left those to the states. And there was an accident on the highway, and then the question was whether the traditional tort, it was a negligent hiring question.
Negligent hiring, yeah.
And the question was whether that was traditional safety or whether that would go under the interstate in the court. That was a Clement case, I believe, and he was representing the injured party in that case. And the court said that I think that was not preempted because it was specific. The negligent hiring claim had not been preempted by.
That's right.
Right. Okay. Well, now we come to the point of our Supreme Court show where Damian Schiff is going to do a parlor trick. He is going to talk about uh, a decision, M&K Employee Solutions versus Trustees of IAM National Pension, a 9-0 opinion from Justice Jackson, and he said he can tell it to us in 30 seconds. So,
Having given the opinion a closer look, I don't think I can do it in 30 seconds.
Go.
Well, the case concerns ERISA, which is a federal law governing pensions. Here, this is a certain type of pension that's common among collective bargaining agreements where you have a union, that's pension for the union. You have a lot of employers who pay into it. Well, what do you do when an employer wants to get out of the pension, wants to stop paying, but it's a pension that is underfunded? Well, ERISA says, here's your formula for coming up with how much you have to pay. And the question before the court here was, all right, well, there's a deadline that the statute says, by this date, we're going to fix your liability. The question is, what is fixed? Is it just simply things like how many planned people there are? What are the assets? What are the current liabilities? Or is it also actuarial assumptions that will be used to figure out your ultimate liability? The court said here that those actuarial assumptions are not date sensitive. They can be selected after the date for withdrawal.
56 seconds.
Not bad.
Okay, so I mean, it's not too bad.
I will say this, well, I have a couple short tidbits. Very well done. That I do remember that argument now. Isn't there some issue, I remember listening to this oral argument, isn't there some issue about whether the clock starts on January 1st or whether you can, is there a timing issue that's related to this case? Do you remember, Damien?
Yes. So everybody agrees that there is a date certain here, and that that date applies to at least certain things like how many people are currently participating in the plan and stuff like that. But then the question is, all right, well, when the actuaries then come up, and then after this date has passed,
Okay.
and the actuaries are now doing their computations and figuring out in terms of predicting how long people will live and all that, basically figuring out what's the total amount then that this company owes for withdrawing. The question is how much of that computational work itself has to be based upon pre-cutoff dates. So here, as I understand it, it's kind of interesting actually. So the plan used to have a discount rate of 7.5%. And under that old 7.5% number, which was before the cutoff date, this particular employer's liability would have been like $1.5 million. The actuary came up after the cutoff date with a new discount rate of 6.5%. And because the discount rate went down, the withdrawal liability ballooned to over $6 million.
Wow.
So that's what the fight is about, is trying to keep the withdrawal liability limited. And the court said unanimously, the selection of the actuarial assumptions, that actual selection doesn't have to happen before the cutoff date. That can happen anytime. But the court left open, I thought, a very interesting question, which is, well, what about the content of those assumptions? Now that the court doesn't say anything about, whether the content of the assumptions has to be based upon pre-cutoff date stuff or post, or can include post-cutoff date stuff. All it said was the actual date that the actuary, signs his name to something, says, okay, these are the figures I'm going to use. Does that date itself have to happen as well before the cutoff date? And the court said no.
Well, as you and I have joked before, one surefire thing that you can guarantee the court will always hear one ERISA case a year.
That's
so maybe
right.
that is that is the next one. An ambitious Supreme Court practitioner may want to start an ERISA practice.
Yes, indeed.
I will say I have a very good friend of mine, shout out James Isaac, who is an ERISA attorney. His work is as boring as it gets, and he is very well off. Not like us public interest lawyers. All right. Let's move from there to another 9-0 opinion. This is a per curiam opinion. Margolin versus what is it? What's that acronym stand for? NIGE?
National Association of Immigration Judges.
Yeah.
Yeah. Why don't you take us down this road, Oliver?
Well, I don't know much about the underlying case, but the Executive Office for Immigration Review adopted a policy that regulated immigration judges' work-related speech. And so this association filed suit in district court, and the district court said that the association had to go through this administrative proceeding. And the Fourth Circuit reversed and did so on the basis of an argument that none of the parties had raised before. And so the U.S. Supreme Court said you can't do that because that kind of advocacy from the bench is improper, and it's called the principle of party representation. In other words, the parties get to, what did I say?
Representations, presentation.
The point is the Fourth Circuit judges were representing one of the parties in the case, which is improper. So it's the principle of party presentation. The parties are the masters of the case. They get to decide what issues are raised, and the judges are supposed to decide only those issues. And this is, I think, not the first time that the Fourth Circuit has done this. I think the Fourth Circuit is now the worst appellate court in the country. They have taken over from the Ninth Circuit. And Justices Thomas and Barrett said that they would have reversed on the merits anyway, but in any event.
Well, I think they said, like, we agree with the court, this wasn't presented, should be kicked for that reason, but they got it wrong anyway.
They got it wrong anyway, yeah. So.
Yeah. Just briefly to add a little bit of meat on that bones, the issue is whether these judges had to bring their claims first through the Civil Service Reform Act, or whether they could sue directly in federal court for a violation of the First Amendment. Justices Barrett and Thomas say, yes, you have to bring it through the Civil Service Reform Act. Fourth Circuit got it wrong. But you're right, the actual holding of the court is you can't decide issues that aren't presented to you. And that was unanimous, 9-0. From there, we're moving through our 8-opinion day. Havana Docks versus Royal Caribbean Cruises, a Thomas opinion. Interesting breakdown in that it's an 8-1 opinion, and Justice Kagan, who does this very, very rarely, is the lone dissenter, a sole dissenter in this case. Havana Docks dealt with the Cuban Revolution and cruise ships.
And usufructuary concessions.
Oh, wow. That's a big word. Usufructuary?
Usufructuary. Damien, did I pronounce that correctly?
Yes, it's a very prominent concept in water law.
Well, as one who knows water law and admiralty law, Damien, tell us what this case is about.
Well, my understanding is that the docks company obtained this concession, as Oliver said, from the pre-communist governing regime of Cuba. And the regime was that, okay, you can build the docks and then you get to use them basically exclusively for profit for like 75 years or something like that. But then in the Communist Revolution of 1959-1960, that concession was terminated by the Castro regime. The docks were physically appropriated, and the concession was ended. And that was basically the end of the story until the 1990s, when Congress passed, I forget the acronym, but it passed a statute basically to try to facilitate the recovery of property by those who were victims of the Communist Revolution in Cuba. But as I understand it, there was a provision in the statute that authorized the president to sort of delay the effectiveness of this new cause of action Congress had created. And so the statute had been basically a dormant, if not dead letter, until the first Trump administration, when President Trump allowed the pause to expire. So once it expired and this cause of action was created, the docks company then filed a lawsuit against 4 major cruise ship companies, who to this day, I think, are bringing their cruise ships to Havana, using the dock for purposes of their cruise business. And the docks company said, all right, well, we can bring this cause of action because it allows us to seek monetary damages and in some cases treble damages against those who basically traffic in property that was expropriated as part of the Cuban Revolution. So the Justice Thomas's majority opinion says that we're interpreting the statute kind of like a taint theory, that if people use property that was at any point expropriated by the Cuban government, they could then be liable to the original owners of that property. So the other side had argued that, well, you know, this concession that the dock company had would have expired in 2004. And the cruise ship companies, who were the defendants here, didn't even start using the docks until after that point. So how could they be liable for taking advantage of the cruise ship's property when it wasn't its property at the time of the use? And as I say, Justice Thomas kind of says, well, no, that's not the way the statute's written, that basically this property is sort of permanently tainted. So there's no question that when the property was expropriated, it was owned. It was a usufructuary interest that was owned by the dock company. That's all that you need to show in order to recover. So it's interesting, Justice Sotomayor, joined by Justice Kavanaugh, concur, but argue that, hey, now there might be some limits to this idea, because the thing is, we're talking about potentially huge liability. I think it's like over $100 million that this dock company can recover against each of the individual cruise ship companies. And Justice Sotomayor says, you know, if you stretch this too far, you could say that, well, I mean, would, like, you know, travel agents be liable who help facilitate, you know, or concessionaires who sell the hot dogs on the cruise ships themselves? Are they going to be liable too? So I think that there is some concern, but there's also too the fact that there are other arguments on remand that the cruise ship companies might have. I think one of them was that there's an exception for lawful transportation activities. These are other defenses that the lower court hadn't addressed the first time. But it is an interesting case because you think, kind of an obscure issue, why of all issues within Justice Kagan decide this is the one where I'm going to be, you know, the lone dissenter? So so there's something here that she's
when she's like on the side of you don't get to recover money.
Yeah. Well, or when she's right.
Yeah, I was gonna go there too.
Go ahead. No, go ahead.
No, I mean, I'll be honest. I haven't read the statute, so it's a matter of strict statutory interpretation. It very well could be that the eight justices have it right. But from a what the hell are we talking about perspective, if the interest in your property is over in 2004 and someone else comes along a decade later and starts using that, how the hell do you still have an interest in that property? It makes no sense to me.
Right, and the statute says that any person who traffics in property which was confiscated by the government, Cuban government, is liable to a U.S. national who owns the claim to such property. So as you point out, the claim they don't own anymore. The other problem was the usufructuary concession, which is what the plaintiffs owned here, the ownership was in the use. So
right.
As Damien said, they could use it.
They never had fee simple.
Right, so they could build it, and then they could use it while they were there. So the government took that property without compensation. So they can't even use it anymore. I don't understand how they can recover from these cruise lines. It's weird to me. And so part of the majority opinion, though, says property can be both an interest and a physical thing. Yeah, no dispute, but they didn't own the physical thing. So I don't get it. There must be more. Again, I didn't read the statute closely either, so we could be missing something, but it just sounds strange.
Yeah. Okay. Well, let's move on to the final opinion, which Damien erroneously called nothing to talk about because it was per curiam. I believe that this, of all of the opinions, this one generated the most paper, and I think there were 70 pages of concurrences and dissentals to a per curiam opinion. I'm talking, of course, of Ham versus Smith. this case was a per curiam opinion. Oh, go ahead, Oliver. It looks like you had something
Well, I
to
was
say.
just going to say this had the most pages, but it also has the fewest number of pages that I read. So before you ask me anything about it,
Well, page 1 is the writ of certiorari is dismissed as improvidently granted. So it was digged. The case was digged, and then there was a concurrence from Justice. Well, let me first set up what the case dealt with. This is, if you remember from the oral argument, I remember this is, I think it was argued in winter, as my memory, in December-ish. This dealt with IQ of death row inmates, whether you put someone to death if there are different IQ scores, and how to sort of parse different IQ scores, the totality of the circumstances test, whether they are mentally fit to be put to death. There is some language indicating that under 70 is unfit to be put to death, and over 75 is fit to be put to death. And this individual prisoner had scores that ranged as low as 72 and as high as, maybe approaching 80. Had an 11th grade reading level. And so the argument from the one side is, well, there were some scores that were in that 70 to 75 range where it's a question, even though there were some scores that were beyond the 75 where it's not a question. And then there was the other side is, well, there was no score below 70, which is the number for not putting someone to death. So that should be enough. The court, despite a lot of argument, a lot of briefing on this issue, and apparently a lot of mixed opinions from various courts, a lot of confusion is what a lot of the paper, the concurrence and dissents go into. They dig the case. They argued it. They had briefing on it. They dig it. They don't give an opinion. They say improvidently granted. And of course, because it is a per curiam and it's one sentence, we don't know why they thought it was improvidently granted. Justice Sotomayor and Jackson essentially say we need to brief it better and more directly in a future case. I think it's a 4-justice dissent from the dig. Thomas wrote his own dissent, and then there was an Alito joined by the chief and Thomas and Gorsuch. So 4 of the justices are dissenting to a dig, which I find crazy. How could the case be improvidently granted if 4 justices are arguing that it should have been granted? 4 justices is all you need to grant a case. So they could just re-grant it. It makes absolutely no, I'm actually flabbergasted by the idea that this case was digged. To read the dissent, Justice Alito dissent, and I should say the Chief and Justice Gorsuch did not join all of Justice Alito's dissent, but they joined enough of it to say, at a bare minimum, this case should have been vacated and remanded for a new opinion. We're not saying that the guy was fit to be put to death or he wasn't fit, but the opinion that the lower court produced was wrong. So let's just vacate and remand and not dig it and provide absolutely zero guidance to the lower courts on an issue that has split the courts, the circuits, and the states. And obviously 4 justices think they should have heard it. So I think this is quite ridiculous, frankly, and don't understand how you could dig a case like that.
and it doesn't seem like anybody disputes that it's an important issue.
Yeah.
And that's what Sotomayor's opinion was about, to the extent I looked at it.
So nothing precedential here. We got a lot of paper to say why the court shouldn't have digged it, but in the end, it's a per curiam dig, and I'm sure we'll hear this issue in the future.
Definitely.
Anything else from opinions that I didn't talk about that you guys wanted to raise?
Nope.
Well, let me move on to what produced an opinion unrelated to the docket, and this is Justice Thomas dissented from the court's decision to deny Florida's complaint against California. Now, Florida filed a complaint in original jurisdiction. Again, the state of Florida filed a complaint against the state of California, essentially arguing that California and Washington are issuing illegal aliens driver's licenses, and this is somehow harming Florida. What the actual merits of the claim are sort of beyond the disputes of whether the Supreme Court has the authority in the first instance to not hear a complaint between states. And Justice Thomas, joined by Justice Alito, writes an opinion that I frankly find pretty compelling, that this is within the original jurisdiction of the court. It doesn't have an option to deny it. It must hear it. And maybe it can issue a per curiam opinion or do something. But the idea that the court can say, now we're not going to hear this dispute between the states doesn't seem like the constitutionally right answer to me.
Well, it's not just original jurisdiction, it's original exclusive jurisdiction. So if if the Supreme Court doesn't hear it, nobody hears it.
Right.
Yeah, it's crazy.
Damien, why is it not crazy?
I agree with you. I think it's, I think of, for example, there was another recent prominent attempt that involved the state versus the federal government in the Utah case, which was actually filed by Paul Clement, I think maybe a year and a half ago, where Utah was challenging the federal government's practice of retaining a lot of public lands as unreserved federal lands, and that in Utah sort of undercuts the sovereignty of the state to regulate its own resources. And that was also dismissed. But this is even stronger because, as all of you point out, whereas the district courts can also adjudicate a case between the United States and a state, the disputes between the states, as you point out, is I think it is exclusive to the Supreme Court. So it's a question of no relief otherwise. So yeah, I agree. I mean, it seems to me clear that they should be taking it.
I guess the only other thought that I had, if I was going to play a little bit of devil's advocate, could the governor of Florida bring a complaint in California federal district court against the governor of California, and therefore it would be like suits against the states or something like that.
But it would have to be, so maybe in his private capacity, but so you're saying in official capacity?
Yeah, in official capacity, then you really wouldn't. Yeah, that's true. So
right.
I don't.
Well, I mean, no, I mean, I think that's true in the sense that I mean, I don't see why a state couldn't rely upon the ex parte Young theory if we're talking about either a privilege that the Constitution affords states among themselves, or we're talking like a preemption issue, which is I think what we're talking about in this case, that the practices of California and Washington in issuing driver's licenses conflict with federal law. Yeah, why couldn't the state bring an ex parte Young action against
Is ex parte Young limited to
the head of California DMV or what have you?
Is ex parte Young limited to 1983 claims?
No, well, ex parte Young, I think, is just simply the I would consider it as just simply the theory whereby sovereign immunity is not a problem.
Because it's individuals of the...
Yeah, and so, if you have a federal claim for preemption, I mean, I don't see why you couldn't bring that.
Yeah, or maybe even if it wasn't the state, maybe some citizen of, I mean, probably going to run into other jurisdictional issues, but I guess my only thought here, other than thinking it's ridiculous that the Supreme Court wouldn't take this original jurisdiction case, is that perhaps there are ways to still bring the issues to the courts in a different posture.
Yeah.
Right.
Yeah, the court doesn't take enough discretionary cases, and now it is rejecting mandatory cases.
Right. Well, I think the big issue so far this term has been redistricting. Calais versus Louisiana being the big blockbuster opinion that we've received so far, holding a new, essentially giving us a new way to view Section 2 claims under the Voting Rights Act in a way that does not violate the Constitution. And in holding that, the court rejected Louisiana's attempt to carve out a separate majority black district, saying it was racially motivated. Voting Rights Act doesn't mandate it, and also sort of lays forth a new test for adjudicating Voting Rights Act claims under Section 2. There were a number of cases pending before the court that got vacated and remanded in light of Calais. One of those is a case dealing with redistricting in Alabama. I think it was at one point originally called Allen versus Milligan. I even think that case made it to the court at one point a couple of years ago. And the court vacated, remanded it, sent it back down to the 3-district panel. And they affirmed. They said, we got it right the first time. There's still a Section 2 violation. Calais doesn't change anything. There's still intentional discrimination going on here, so you still have to create a majority black district in Alabama, which frankly, I could have called it. When they didn't hold that that Section 2, insofar as it may require race-based districting, violated the Equal Protection Clause and left open an avenue. It took all of 1 month for the plaintiffs to find a willing court to say, no, this is the one that presents the case. Even though, so the big things to come out of Calais were you have to disentangle race from politics. You have to show that that was one big point. You have to show that you can meet the state's non-racial goals, or the state's bona fide interests in maybe partisanship or compactness or whatever they say that their bona fide goals are, with a different map that does it in a way that preserves those interests. Of course, they didn't do any of that. And yet the district court says, or the 3-judge panel of the district court says, still intentional discrimination. We're still going to find a violation of Section 2. That has been petitioned the court for a stay of that opinion. And we are awaiting, I believe, so the United States filed an amicus curiae in support of the applicant, in support of the state of Alabama. I think we're waiting for respondents' brief is due on Monday. But I don't know. When you leave a little door open that allows for race-based decision-making, the people that like race-based decision-making are going to drive a semi-truck through it, and that's exactly what happened here. I hope, beyond all hope, that the court provides some guidance on this, although given all of the hoopla that we're going to get to with their Calais decision, I suspect they didn't want to have to dip their toe into more redistricting issues this term. But if they don't, I don't see that Calais is going to have the force that I think it was intended to. So just a big mess that I think is of the court's own making. Thoughts from my learned colleagues?
I mean, as I recall from Justice Alito's majority opinion in Calais, I got the sense that you pretty much have to have the map. You have to be able to produce the alternative map. And so you're saying that the court here says, A, there's no map, but B, we don't need it. So how do they establish the inference of race, use of race?
I haven't read. I mean, this is all very fresh this term. I mean, this week, I've only skimmed. They certainly pay lip service to Calais and say that we are disentangling, that there's enough evidence here of intentional discrimination. I also think that there is some discussion of sort of timing necessitating them not really going back in and producing maybe what we would think they would need to produce. In other words, because we are so close to an election, they didn't have to produce a map. Maybe that's part of the argument. I'm speculating now. We will get the NAACP's brief on Monday, and so for next week's edition of the PLF Supreme Court Show, I'll be sure to fairly present their arguments of why the district court got it right to hold a Section 2 violation. But at this point, I am highly skeptical and a little bit annoyed.
Yeah.
Okay. Well, speaking of redistricting, Justice Jackson was in the news when she spoke to some Washington, D.C. lawyers and said that the Supreme Court is getting too political, and that is exemplified by its decision in Calais and the decision to expedite the decision because normally they wait 45 days to issue the judgment. In this case, they didn't, and that was political, and that's why I dissented. Thoughts, Oliver?
Well, her she made those points in writing too, and Justice Alito, in his I forget what concurring or whatever opinion, said that we can't let these statements go, and criticized her and said, who's being political? If we had let the time run out, and I think the issue was, as you said, normally the judgment comes out 45 days after and so the government moved and said, we have an election this fall, can we get the judgment sped up so we can start acting? And he said, would it have been non-political to have denied that and therefore held up the printing of ballots for the election?
Right.
It just, yeah, I mean, the decision was made. What is and as he pointed out, the other side opposed it, but didn't say that we were going to seek reconsideration of the judgment.
Right.
And then in response said, oh yeah, wait, we want it now. After the decision came out. So there's certainly politics happening at all times, at least to some extent. But the decision was made. And again, Jackson's on her own here. Sotomayor and Kagan at least didn't want to make those claims publicly. So I don't know. It seems like she's out on the limb here.
Well, I haven't, I recall reading briefly her opinion, but I haven't seen her remarks from this presentation. But is she just simply saying that it gives the appearance of politicization, or?
Yes.
Okay. Yeah, I mean, sure, but you could say the same thing about every Supreme Court case. I mean,
Right.
It seems like every controversial case is going to be susceptible to some sort of political characterization. But I mean,
And as Oliver points out, if they had done the exact opposite, that could have been perceived as political.
right. Well, and as Justice Alito noted too, why did it take 9 months to produce? I mean,
Oh, that's right.
yeah, I think he was suggesting that, well, maybe there was some strategic delay. Moreover, what are we talking about? Rehearing? How often is rehearing granted? And I mean, it's not as if some new thing has happened that will radically change the fact. I mean, it would just be a second bite at the apple request.
Yeah,
So,
and-
I mean,
and-
what's
The point about slow walking, I mean, Alito's opinion, I'd forgotten this, suggested that the decision was made at conference right after the oral argument.
yeah, in
And that-
October, I think, right?
Yeah, and so why did it take so long for the opinion to come out? So he's suggesting maybe there was some shenanigans going on to delay release of the opinion,
Yeah.
which would have the effect of perhaps delaying or.
It is interesting to think, though, what Justice Jackson thinks she's achieving, because it's probably true that Justices Sotomayor and Kagan probably share to some extent her critique of certainly the consequences of the decision and maybe how it would be perceived, but they're not doing the same thing. Although Justice Sotomayor did have that controversial speech recently, where she referred to Justice Kavanaugh as being not.
Which she apologized for.
Which she apologized for, right. Whereas Justice Jackson is not apologizing for anything that she's saying. So I wonder, I mean, what do you suppose she thinks she's getting out of it?
Yeah, I don't know. I mean, popularity. She's getting written up in the Washington Post.
She's on Broadway.
She's on Broadway. I will say that I think Oliver made a good point right at the beginning, is that this is mostly a non-story. She wrote in a published opinion exactly essentially what she said to this DC lawyer. So why do we need to write about it? I mean, she took the greater step of publishing an opinion about how she thought the court was political, which was ridiculous, and her own opinion, not signed on by anyone. The fact that she went and said essentially the same thing in a meeting of DC lawyers is is almost a nothing burger.
There are rumors that Sotomayor and Kagan are a little not happy with her because maybe she's hurting chances of consensus. I don't know how true that can be. It seems like on the big issues, it seems like the 6-3 split is pretty strong.
All right.
Could I just, just to bookend it so that we can be perceived as fair by our listeners.
Mm-hmm.
You know, there was that controversial speech that Justice Thomas gave, about a month or so ago at the University of Texas, was it? Talking about the Declaration of Independence and progressivism and some of his comments, I guess, being construed as perhaps criticisms of how the court's being.
Well, much like when Kagan dissents alone, perhaps he makes speeches like this when he's correct.
Very nonpartisan answer there. All right. Exciting week exciting 2 weeks at the court. Looking forward to more opinions next week. I want to ask you guys some trivia questions. You guys ready for it?
Sure. Is there an
Who's got the
airplane
wind tunnel
landing
right
near
now?
you?
Pardon?
Is there an airplane landing near you?
Is that my wind tunnel? Is that
I don't
coming
know.
too? Let me try muting and see.
Still hear it?
Probably you, Oliver.
Probably.
All right. My trivia questions today concern, since we're nearing the end of the Supreme Court term for 2025, I want you guys to look back at the previous 4 terms. This is term 2024, 2023, 2022, and 2021. And I want you guys to name 2 of the big blockbuster opinions from each of those terms. And we'll go. Let's start with 2024. You each got it. So this is last year. Last year, what? And I have 5 cases that I will accept as the correct answer. And Damien, we'll start with you. What was one of the blockbusters from last year?
Jarkissi.
That wasn't last year.
That's what I
Local
was going to say.
Still not last year. But you did
Seven
get 2
counties.
for 2023.
7 county.
No.
7 county infrastructure.
The EPA case out of San Francisco, that's what you're talking about?
No, I was talking about the NEPA case, but maybe that was also more than.
Nobody cares about NEPA but you.
Okay.
Kilo.
You guys.
I have no idea.
Last year. This was less than 365 days ago.
Well, we weren't party to this program last year, so we weren't
Loper
following
Bright?
the board closely.
No. You'd litigate Loper Bright. It wasn't
know.
last year. All right. I'll have to give you a clue. One of them dealt with transgenderism.
Skirmetti.
There you go.
There we
Very
go.
good. And one of them dealt with universal injunctions.
Casa.
There you go.
Okay. Now
Okay, well, that will be 2 from last term. There's Mahmoud versus Taylor. That was the religious freedom in K-12 education. United States versus Miller. Do you remember that one? Ghost guns.
I thought that was from 2 terms ago.
All right, 2023 I'll already give you. You already got Loper Bright, Jarkissi. Trump versus United States would have been acceptable. That was whether he could, the presidential immunity. I would have accepted corner post. All right, 2022.
Wilkins.
Sackett.
You guys are awful. What was the big equal protection case?
Oh, Bostock. No.
No, the Harvard case, right?
Yes, students for fair admission.
When was Bostock?
Bostock was like a decade ago.
No.
Yes.
I think it was pre-COVID, actually.
Really?
I think so.
Also, a case from 2022, Oliver, is one that I think you had a competing petition where we filed, I think we were the first to file a case challenging this thing.
The tariff case?
That was this year, Oliver.
Oh, that was this year.
You are so old. Biden versus Nebraska, student loans.
Student loans, student loans. Yeah.
That's right.
Oh, West Virginia v. EPA. That's a blockbuster.
That was the year before. That
Okay.
was the year before, 2021. So I will give you that. I'll give you a point for that, Damien. You're the only one that scored any points.
Gee.
I would have said Jarkissi.
You didn't. All right. But the big decision from the West Virginia versus EPA year, 2021, term 2021.
That is Dobbs.
Dobbs, thank you. All right. Also would have accepted Bruin, 303 Creative from the next term. All right. Well, you guys really stunk
When
it up.
Yikes! Yeah, that's not very good.
When was Sackett too, Damien?
I thought it was 2022.
Yeah, that was term 2022.
Yeah.
Oh, it wasn't too far off.
All right. Well, I'm embarrassed for you guys, but we'll nevertheless be back at it with another Supreme Court show a week from now to talk to everybody about the latest happenings at the Supreme Court. Hopefully, some more opinions, maybe some grants, and anything else that Justice Jackson decides to say to a room full of DC lawyers. Thank you, fellas, and thanks to our audience who's been tuning in on Twitter and YouTube. We'll be back same time next week. Have a good week.